All right, I think we'll get started. Good morning and welcome to this month's session of your morning briefing, a monthly webinar series designed to keep you informed and ahead of the curve on labor and employment topics, all in the time it takes to finish your morning cup of coffee. I'm Anna McCarthy and I'm joined this morning by guest host Liz Lindhome.
Hi, good morning. I am an attorney at Harder Seacrest and Emery's Immigration Practice Group.
Thank you so much for joining me, Liz.
It's happy to be here.
So today's morning briefing is going to cover the high points of employer interactions with immigration authorities, and that's Liz's area of expertise. So we're going to talk about the many changes that we've seen in immigration enforcement over the last 6 months under the Trump administration, and we'll go into detail on some of the practical advice for advising employers on addressing immigration issues in the workplace, including tips regarding record keeping and addressing employee concerns. And as a bonus portion on the labor and employment side, I'm also going to be talking about the New York State Retail Worker Safety Act, just briefly for a couple of minutes, and then we'll get into your area of expertise, Liz. So before we get started, I just want to cover a few housekeeping items. The webinar has been approved for a half credit of HRCI and SHRM and CLE credit, and we'll give some instructions at the end for how to submit that later. It's intended for general information purposes only, so this webinar should not be considered as legal advice, even though Liz and I are attorneys. All participants' lines are placed on mute, so to submit questions, either technical or content related, please submit a message via the Q&A widget on your toolbar. Don't use the raise hand feature because we won't be able to see that. Feel free to submit those questions at any time, and then hopefully Liz and I will have a chance to address them at the end as they come in. We'll try to reserve some time at the end for that. So now we'll just dive into my very quick spiel on the Retail Worker Safety Act.
Wait.
And then we'll get into some of the immigration related content. So Liz, I'm sure you've been dying to know about the Retail Worker Safety Act.
I've been on the edge of my seat.
So this is Labor Law 27E. It was signed into law in the fall, and then it was amended earlier this year. It became effective June 2nd, 2025. So if you are a retail employer, you may be familiar with this law. The trick here is, and Liz and I actually were talking about this a few days ago, that you may be covered even if you don't realize that you may, even if you don't think you might have been covered, you may be because of the way that the law describes covered employers. So covered employers are anyone who employs 10 or more on-site retail employees.
Okay.
So a retail employee is defined as someone who works in a retail store, kind of circular logic here. But the way that it's defined, kind of funny enough, it will include employers who are not retail stores at their core. So maybe you have a retail store or a retail aspect of your business that's a part of your business, but it's not the entire thing that you do. Or maybe you're a business that interacts with retail stores. You might even be covered in that circumstance. So you don't have to be a retail store, but if you're interacting with a retail store or you have employees that work in a retail store location, you may be covered. So if you've got 10 or more on-site retail employees, you should pay attention to this. The purpose of this law is basically to reduce the risk of workplace violence, reduce the incidence of workplace violence, reduce safety concerns in retail store locations. So the basic requirements are to implement a written workplace prevention policy and then have training on that policy. You have to implement it, hire, and then annually thereafter, you have to distribute it. That training requirement is once a year, unless you're a smaller employer, less than 50 employees, and then it's once every other year to do training on your workplace safety policy or workplace violence prevention policy. So those are the basic requirements, the written policy, written notice of the policy, and the training requirement. The only other requirement that people should pay attention to if they're large enough is the requirement to have a silent response button to request assistance from a security officer, a supervisor, or a manager. That only applies to employers with 500 or more employees in New York State that are retail workers. So that will only apply to a small subset of people. I said this was going to be very quick, and I meant it. Please go to dol.ny.gov/retail worker safety, and there are hyphens between retail worker and safety for more information. And if you're interested in learning a little bit more about this, please let us know. We can always do a longer Your Morning Briefing session on the Retail Worker Safety Act if there's interest. But I just wanted to provide that very quick update so that you're aware that that's out there in case you need to be complying with that law. So with that, we're going to move on to the big topic of this morning. And again, the area that Liz practices in. So let's start with what seems like an obvious question, Liz. Why are we talking about immigration enforcement? Why is it such a big topic right now?
Yeah, really great question. Many of us have seen in the news that this is really ramped up. Immigration enforcement generally over US history has been constrained by two things, really. One is political will. We have a lot of laws that are really complicated to enforce, and they could apply to lots of different people, and so there's an amount of political will that's required to go forth and really enforce those laws. The other piece is budget. It costs money to arrest people, to find people, to investigate. It costs money to detain people. All of this is incredibly expensive. And for the first time, certainly in my career, but probably in the modern immigration era, we have both of those constraints seem to be pretty loose, if not completely gone. We've had the big political will for the last 6 months, and we just in the big beautiful budget bill that was passed saw an incredible increase in funding for immigration enforcement. Just to throw some numbers out there, it included $30 billion with a B dollars for immigration enforcement for the next 5 years, 4 years. And the plan is to hire over 10,000 ICE officials just under the immigration and enforcement branch, which will bring their numbers higher than the number of special agent FBI agents that we have in the entire country.
Wow.
So there'll be more ICE officials than there are FBI agents.
So even though we've already seen a ramping up, it sounds like this is maybe only the beginning of some of the enforcement actions we've seen.
That's right. Yeah. Yeah. They've definitely got a filled up tank.
Okay. So let's talk a little bit more about those specific enforcement actions.
Right.
We talked about the fact that there are apparently currently resources and the will to do it, and there will be even more coming down the pipeline. So what specific enforcement actions are we talking about that these dollars will go towards?
Yeah, the big areas seem to be focusing on just the manpower of enacting lots of enforcement actions. And I keep saying that, but kind of the big categories are employment based, like working in the United States without authorization is a violation of the law. Hiring people who don't have work authorization is a violation of the law. And so those are really big buckets that a lot of folks have been, let's say, slipped through the cracks, or people haven't bothered with until the recent era. Other enforcement actions include, the more, let's say, dramatic areas where there's criminal enterprises, human trafficking, drug trafficking, trafficking in knockoff goods, violating trade laws in that sort of way. So they're all also under the immigration enforcement branch. And then we also have lots of little side areas that we're not really thinking about as being related to immigration. Like if you are a company that sponsors foreign workers, you have requirements to the Department of Labor, and they can investigate. And you have requirements to the branch of ICE known as HSI, or Homeland Security Investigations, to make sure that you're following all the rules about their wages and working conditions, to kind of, from both ends, make sure we're not engaging in those really nasty crimes like human trafficking and that sort of thing.
Sure. Now, you mentioned specifically employers that might have employees that were not born here. So maybe they're visa based, whatever it is. Are those the only employers we're talking about, or what's the scope here?
Yeah, the scope is a great question. The scope really is any employer, in particular in the space of I-9s. It's the form that employers have to fill out to every employer if they're hiring somebody for any kind of work for remuneration, no matter how big or small. You have to fill out this form to show that, as far as you know, this person is authorized to work in the United States. So every employer has to have an I-9. I was even looking this up. If you hire yourself for your own company, you have to fill out an I-9 for yourself. So it's everybody. And I-9 enforcement is one of those areas that can cast a really wide net. And for an administration and a system being set up to catch as many violations of the law as possible, it's a really great tool for them to cast this really wide net and see what comes up.
Okay. I definitely want to get back to the issue of I-9s, the record keeping requirement, and how that might be maybe an avenue in terms of government interaction.
Right.
But I want to talk a little bit about some of the other enforcement actions that you had mentioned, or that might fall under the umbrella of what we're talking about. So maybe let's start with an ICE raid or an
Right.
agency warrant, something pretty significant. And frankly scary sounding, maybe for some employers who haven't had this type of interaction before. So what would you recommend in terms of preemptive measures? So it hasn't
Yeah.
happened yet, but
Right.
what should employers be doing to prepare?
Absolutely. The most important thing in this is to be proactive, which is exactly the question that you're asking, right? Think about how you want to handle this and what policies make sense from a broader scope. How does your company want to interact with law enforcement? If a police officer, if an FBI agent, if ICE shows up and asks for a certain person or asks for access to a certain area, how do you want to respond? Using that, thinking about company policy and values from that point of view is a great way to build, okay, how do we effectuate this policy? So a couple of key things to think about are the types of actions you might see, how they might come about, who they might be from, and where these folks can go. Um, the types of actions really depend on what kind of paperwork they're bringing. In particular, I want to mention that maybe in January it was only ICE officials and they had the badge that said ICE Immigration Enforcement, very clear who you were talking to and what they might be there for. In February, the Department of Homeland Security authorized the department to deputize any federal law enforcement official. And so anyone of any badge at any federal level could be enforcing immigration rules. So you can't rely on what the badge says. You can't rely on what the gear says as to who you might be dealing with. So it could be an ATF officer, but they're enforcing immigration rules. So it's really important that whenever someone shows up, you look at the papers. They could be serving an I-9 audit notice where you have 3 days to send them paperwork. It could be that they're there for an ICE raid and they're about to try and arrest everybody. And it could be just about anything in between. So it's really critical to have a policy in place that you are giving permission where you want to give permission and you're not giving permission where you don't want to give permission. And I know I'm kind of going to the end of my list here and what areas they can get to. One of the things that the Constitution provides is that you are protected against unwarranted searches and seizures. And that means the government can't just barge into your house or your business and start looking for things without a warrant.
Okay.
When we say that, normally that means a judicial warrant. That's a warrant that is signed by a judge, that's dated, it's specific. An independent judge, magistrate has decided that the government has the authority to go look for the thing they're looking for. There is another kind of warrant that a lot of these officers and agencies use, and that's called an administrative warrant. And that, to be maybe a little pejorative, is kind of like writing your own hall pass. It says, I authorize myself to do the thing I want to do. So it's ICE authorizing ICE. There's nobody supervising what the request is. So the key difference here is an employer has to comply with a judicial warrant. They don't have to comply with an administrative warrant.
Okay.
So I would think as an employer, maybe my first question is, how much do I want to comply? Because there's no harm in complying with an administrative warrant. You're more than welcome to let them use their hall pass. If you're concerned about access to your employees or to information or certain private areas of your business, then think more carefully about how you want to handle granting that permission. I also think a lot about, if you have private information, if you have to comply with HIPAA or if you have to comply with any of these privacy and data rules that I'm not an expert in, but I know they're out there and very serious.
Sure.
how do you deal with the interaction of those requirements? Because you don't want to give too much permission in one space and then wind up violating the privacy and protection requirements in another space.
So it sounds like it's worth thinking now about what information or records or property you have that you would think would be private,
Right.
and what is okay for maybe the public, or in this case, government officials to have access to in the first instance. So maybe sort of dividing things up like that.
That's right.
Does that extend to space in your workplace?
It absolutely does. So immigration enforcement officials are absolutely within their authority to enter any public space and start asking people questions. That could be customers, it could be employees, it could be, anyone, any member of the public. Even if it's your private business, if it's still a public space, they're allowed to just start investigating, let's say. In a private space, they're supposed to need permission or a warrant to enter those private spaces. And the distinction is a little fuzzy. So an example I like to use is in a cafe. The cafe area where anyone can walk in and order a cup of coffee, that is a public space. Behind the counter where, someone wouldn't walk up and start making their own cup of coffee at the espresso machine, that's a private space. And so is the back area or the kitchen or, where all the secret coffee decisions are made. I don't make a lot of coffee. And so the limit to how much these officials can come in and again just start asking questions and asking to see papers is defined by that private or public space. And something to think about for an employer as you're implementing whatever your policy winds up being. If you're like, this is our private space, we don't want someone coming in here willy-nilly, have a sign. It could be as simple as employees only. It could just say private space, no admittance, any kind of signage that clearly delineates that.
Okay.
And that's supposed to be a clue to the officials like, hey, I need permission or I need a warrant to get to this area. But there's really not a whole lot to do about that public cafe space.
Okay. All right. That makes sense.
Yeah.
So we're talking a lot about precautionary measures, putting a policy together about how you might interact with government officials when they come, talking about designating public and private spaces, maybe designating someone responsible for doing all of this.
Right.
What actually happens when you have ICE show up, a government official show up? What are some sort of top tips employers should keep in mind for that interaction?
Yeah. My number one tip is make sure the folks who, if you have a receptionist, if you have, that front door entryway person, make sure you train at least them, but preferably everybody on what the policy is, however you wind up wanting that to be. My recommendation would be that everyone knows to say, I do not have authorization to let you enter this space. Let me call the person who you can talk to, and have a designated kind of like team or strike force or whatever, like 1 or 2 or 3 people on a phone tree that if something happens, they know they are the ones to get the call. They know the phone number for the lawyer to review whatever papers they have. They know what the company policy is, if it's to honor administrative warrants or to not. And then frankly, if the officers proceed without permission or without the necessary warrant, or if there's a disagreement about how much authorization they have, that they know the correct way to document what they believe to be possible violations without obstructing or getting in the way or causing more trouble for the company.
Sure. I mean, I imagine it would be inadvisable to maybe physically
Definitely
engage. You don't want to put your safety at risk. You don't want to put the safety of your employees at risk. Right. But it sounds like you're saying there are important things to think about if you believe a government official maybe is going beyond the scope of their authority in that moment. It sounds like you would recommend documenting what's going on.
That's right.
And what's the process for that?
Yeah, really, whatever feels safest, whatever feels most doable, if that's filming on your phone, if that's recording audio, or if it's taking notes as soon as you can. Walk down aisle 12, officer looks like this but didn't give badge number, whatever that looks like. having records as much as possible about how you complied and about who did what, when, and where. That's going to be the most critical element for you if there are actions against the employer someday about theoretically employing unauthorized workers
Mhm.
for employees. Sometimes and forgive the legal jargon perhaps, but the exclusionary rule where in criminal court cases and see on TV, like if it's the fruit of the poisonous tree, you're not allowed to enter that evidence into against somebody.
Mhm.
That rule doesn't usually apply in immigration, but cases have been found, or courts have found that in some cases where it's such an egregious violation, they will use that exclusionary rule.
Okay.
So it's not a get out of jail free card, of course, but it's having as many resources and tools and information at your disposal so that as the long and arduous process of shaking out whatever just happened, you have as much information as you can.
Okay. So, what should employers know maybe and I know this is hard to capture in just a few sentences, but what should employers know about employees' rights? What's important to
Yeah.
understand?
Yeah, I think for employees, one crucial thing that I think is important is there's a big distinction between letting someone know that they have the right to remain silent and telling them to be silent.
Mm.
In immigration enforcement, that goes from informing someone of their constitutional rights that every person in the United States has, um, by telling them you can remain silent. Instructing them to remain silent can be implicating the employer in conspiracy or obstruction, or could be used as evidence to like make a claim of human trafficking. Worst case scenarios, of course, but if in the stressful moments of theoretically a raid where officers are coming and telling everybody to line up by citizenship
Mhm.
and kind of blowing past the receptionist and whoever to make that happen. It's again really crucial to train anyone that you can say you have these rights. What's the phone number you want me to call? Whatever the situation is, but be clear about supporting or informing of a right versus instructing someone to use it.
Right.
That would be
Okay.
point one. Other rights that employees have, I mean, they have the right to due process. They have a right to remain silent. Um, that's kind of the two big important ones
Sure.
in these high intensity moments.
Mhm. From an employment perspective, I think when employers call and ask me about a question they might have received from an employee
Yeah,
about, their rights in a certain situation, usually we err on the side of, hey, as an employer, you're not an attorney, you really shouldn't be advising employees on, their legal rights or responsibilities in any particular situation,
right,
because if we were to get it wrong, that might have consequences for the
right.
employee. I do think, though, it sounds like employers should at least be aware of what employee rights are,
Yeah,
because that might inform the way the employer interacts with a government official. And I think on a
that's fair.
related note, I think you may have an employee that comes with a concern
Yeah.
to an employer. Now, it may be a concern about the individual themselves,
Hmm.
or it may be a concern that they have about somebody else in the workplace. And you may have seen this come up. I know it's come up for me where an employee will come to an employer and say, hey, I think so and so, might not have the proper work authorization. I have a concern about this individual. Now, the an employer should not be brushing off concerns like that.
Right.
But I think from an employment perspective, employers should be thinking about responding to that in a non-discriminatory way. So what is the basis for this employee's concern? Are they basing it on the fact that someone might be speaking a language other than English, or are they basing it on a conversation they overheard about someone obtaining false
That's exactly
documentation?
right.
So if it's based on a language concern, that sounds to me like maybe their concern is rooted on a potential discriminatory basis, and you want to be very careful about not, as an employer, interacting in a discriminatory way,
Right.
and sort of giving credence to concerns that are not based in
Right.
fact, are not based on a non-discriminatory basis. But from the on the other side, when maybe it's a concern about false documentation, that makes me think about what we were talking about earlier, those I-9 records,
That's
the
right.
work authorization records. So in just the few minutes we have left, can we talk a little bit about employer responsibilities for I-9 records, work authorization records?
Absolutely. Yeah, I mean, the biggest takeaway here, I think, is prepare, think in
Mhm.
advance. And the one really big thing employers can do is self-audit their I-9s.
Okay. And what does that mean?
Yeah,
Self-audit.
yeah. So I-9 enforcement it's generally you know, no one's looking over your shoulder while you're doing it. It's all after the fact to make sure you did it right. So the government can audit you, and that's very stressful and can come with penalties and fines and all sorts of problems. But you
Mhm.
can also audit your own records to make sure, oh, have we been doing this right? Am
Mhm.
I using the right form? Is this the right procedure? Do we have all of this correctly? And that's a really great way to catch problems because it's always better when you find your own mistakes than when the government finds them, right? So I really recommend some version of a self audit.
Okay.
The very next recommendation is to make sure you're following the regular guidelines for that because just like there are requirements that you not employ anybody without work authorization, there are also really strong requirements against discrimination. So
Okay.
you can commit document abuse, which is the passport is okay, don't worry, but you don't want to ask for more documents than you need because then you're abusing the potential employee with this I-9 form. That's
Okay.
one very basic example.
Mhm.
Um, you can trip into discriminatory practices if you only self audit all of your employees with Arabic sounding names, for example, so you want to be really careful about how you go about everything. And
Mhm.
it almost in many ways, imagine this isn't a hot button immigration issue. Imagine it's a paperwork issue. And what's the right way to do that?
Sure.
You know, um, Another element, just in the example you gave, if someone has a credible concern about documents, that can become knowledge, actual knowledge, or even constructive knowledge of that you're violating the rules. So maybe a downside of self auditing and doing all this is that you have to take action with the information that you find. But
Right. Okay.
our job is compliance. Your job is to comply with the law. We want companies to be compliant with the law, and that's what you have to do.
Sure. All good tips. I think because we're getting close to the top of the
Yeah.
hour, I just want to read off the codes for everyone, which will appear on your screen in just a minute. So we'll see if we have time for maybe a question or two now that we're close to the top of the hour. But before we do that, the CLE code is IRCA 25. That's IRCA 25. HRCI credit for this webinar. The activity code is 712241. And the SHRM code is 24-4, E as in Edward, 62, C as in Charlie, and they should all be appearing on your screen right now. You can enter those into their respective portals to submit for credit. We're again almost at the top of the hour, so before we get to maybe a question or two, I'd just like to say thank you for joining me and Liz this morning, and to keep an eye out for an email following the session with information on upcoming webinars. And also thank you just attending this morning and joining us. So Liz, is there a question or two that we might have time for? I know
Yeah.
we've seen some questions rolling in. I think we've addressed some as we've been talking, but in the next maybe minute or two, any
I
last minute questions to
absolutely, yeah,
address?
I'll do my best. One thing we didn't really talk about is when you are sponsoring foreign nationals and compliance around that. I did mention that the DOL wage and hour division, in particular, if you have H-1B employees, there are certain requirements that you maintain what's called a public access file.
Mhm.
And as you might guess by the name, that means the public is supposed to be able to access that file at any time. Um, and the Department of Labor can come in and check and access it as in that and audit you essentially in those documents. The other piece of that is that they have to confirm that you're paying the wage, at least the prevailing or actual wage that you provided. So there are extra requirements with that. I would say reach out to your competent immigration counsel to learn more and to make sure all of your ducks are in a row in that space. But that's another thing that you can self audit to make sure your public access files are looking in tip top shape. Um, Let me see. There was one other question. I perhaps misspoke. I may have said that ICE comes to arrest everybody. They might be casting a wide net.
Okay.
If they have information that 20 out of the 50 people at a plant are working without authorization, they'll come in and check everyone's documents and arrest anyone who they don't, or they'll try. And that's kind of where, how do we want to handle what kind of warrant they have? Do we tell them to come back with the judicial warrant? All these kind of decision trees about how to manage um an event like that. But they can do what's called collateral arrests, where they go for one person but find 20 other people who they think they can arrest, and they will arrest all of them.
This almost seems like an opportunity for almost a tabletop exercise.
Yeah.
So sitting down and thinking about the
Yes.
different potential hypotheticals and how you might respond
That's
to them,
right.
which may be helpful to do with counsel, or with the person in your business that's responsible for sort of the human resources end of things.
That's right. That's right.
But so thank you so much, Liz, for your expertise today. I know we weren't able to get to everything, but this was a really great high-level overview to think about some of the pain points here. What should employers be thinking about, and what are some of the proactive measures they can
Yes.
be taking to address things before you end up in a difficult situation, so that you're as prepared as
That's
possible.
right.
So thank you for joining me this
Thank
morning.
you so much for having
I
us. This was really
appreciate it.
great.
All right. Until next time, thank you, everyone.